All right, it's 11:32. I think we're going to get started. Jim, if you're ready.
Yep, and I
Okay,
will
great.
turn on the video.
Wonderful. Well, good morning. Thank you so much for joining us here today for this wonderful workshop. We're going to be talking about estate planning for second marriages and blended families. I am Tasha John. I'm an attorney here with Cunningham Legal, and I'm joined by Mr. Jim Cunningham, the founder of Cunningham Legal.
Hello, good morning.
Just a few little housekeeping. If you have questions as we go along here today, please go ahead and type them into that question and answer box. I'm going to be checking those and saying those questions and asking them to Jim and trying to answer them as we go along. We try to keep this pretty short. I don't know how long it'll be. It's the first time we're doing this seminar, but it could be just 40 minutes, maybe under an hour is what we're going to try to keep it to. But we'll have time at the end to answer some questions if you want to ask them once we're finished. All right, so I'm going to go forward to our slide here. I wanted to say that, I'm an attorney and Jim is an attorney, and we're here talking to you today, and we're going to be discussing a lot of different topics and legal terms, but this is not legal advice. I hope you take a lot from it. You've taken that education, but legal advice is when we get to meet with you one-on-one. And we get to discuss your specific unique situation, and you'll have that opportunity. We will offer to you a free consultation at the end of this seminar, and we'd love to meet with you, but it's at that time that it will be legal advice. But please take notes and jot things down for us, because we'll be happy to answer questions as we go along. Wanted to tell you a little bit about Cunningham Legal if you don't know too much about us. We are a firm that is based out of Auburn, California, but we are spread throughout California. Jim, our founder of our firm, started this firm over 25 years ago down in Southern California. So you'll see that we have offices in Northern California, but we, in addition to that, have multiple offices down in Southern California. We are a firm that is a little bit unique. We specialize in this area of estate planning and trust administration. It means that we don't just once in a while get around to making sure people have plans that work and that are successful. We dedicate our careers to being very up with education and tax law and making sure people have plans that work. Jim Cunningham with me, he's a certified legal specialist with the state of California, and to be a certified legal specialist, you have to take a second bar exam, be practicing for a certain amount of years, and get recommendations from his peers. So it's a huge accomplishment. Not too many people in the state of California go through this process to become certified. So, and we do have currently 3 attorneys that just passed the certified specialist exam, which is a huge accomplishment. So they're going to continue forward with that process. Myself and another attorney within this firm, we went a little bit of a different route. We both went back to law school after being practicing attorneys. I did an additional...
Glutton for punishment. Glutton for punishment.
I know, we're committed. And so I went to additional 3 years of law school for an upper degree and master's degree, specifically in estate planning and taxation. So you can see we really love what we do, very dedicated to this field, and of course here to assist you going forward. All right. Okay, why are you here today? Well, the topic we're going to be discussing is blended families. So the importance of planning for blended marriage families, and we'll discuss what really does that blended term mean and how is it going to apply to you, and what makes this planning really different, because it is really, really unique. Here's the thing is that every family structure is unique. I've never done a plan that's the same. And that more traditional family structure we think of, where it's a husband and wife and they have 2 joint children, even in those situations, things can be a disaster and really need a direct plan. But with blended families, you're going to see it's very different. The laws are going to apply differently to you, and the planning needs to even be more intentional when you're meeting with your attorneys. So we're going to talk about some of the considerations of balancing your goals, because they're going to be a little bit different, being that you fit into maybe this category of being a blended family. We have the consideration of other children from prior marriages, your current children, your spouse, all your loved ones in your life. And there's going to have to be a discussion of balancing your goals. All right, so we're going to begin with what is a blended family? What does this term mean, blended? And, Jim, I feel like it's a little bit of an archaic term to be speaking about blended, but I'd say it pretty much it can include anything, everything that is not just I'm married and we have joint children. And so I wanted to give a couple examples, and Jim, jump in here. The first type of example would be very much like the Brady Bunch. You have children, you're married, you had a previous marriage or relationship either ending in a divorce or someone passed away, but your children are of similar ages, right? So they're going through the same stages in life. And each spouse is going to have really different priorities when it comes to this. There could have been assets that each one of them brought into their joint estate, and they're going to have to give some considerations as to how am I providing for the spouse if I passed away, how am I going to provide for my children from that previous marriage. So all of those things are what we're going to talk about. It's very complex planning when it comes to that. And there's
Yeah,
also, yeah, go ahead.
well, and I was going to say, lawyers, we put labels on things to quickly identify them, and every person's situation is completely unique. I mean, even if it's a husband and wife and 2 kids with no prior marriage, everyone's going to have its own little unique qualities, but those tend to be amplified when you have people who do not fit that category. So it's almost like blended family is everything else that isn't husband and wife first marriage or spouse's first marriage and children. So this is very important. If you don't have children, or you know somebody who doesn't have children, in a way, that's kind of a blended family, because many times the in-laws and the siblings and the nieces and nephews get involved. And so when we talk about blended family, we're just kind of talking about that penumbra that sort of covers all these other situations. Now, many people cohabitate and they aren't married. Those situations, we kind of dump those into the bucket of blended family, because you'll notice it doesn't say that people are married. So many times people will cohabitate, and the reason that they don't get married is because at least one of the people who is cohabitating is married to somebody else, which presents a whole other host of problems. That couple never got a divorce for a variety of reasons, but that is a blended family as well.
Sure. And two, I have many couples that, like Jim was mentioning, stay married, maybe have been married for 30 years, but they've been living completely apart for 20. And they have both significant others and they're living kind of separate lives. But that can be a really complicated planning structure, taking a look at their property and what are their goals, going forward. Another example would be, unlike the Brady Bunch where everyone's similar ages, it's a family that has a variance of age between the spouses, but also between their children, different generational levels. So different stages of life. And sometimes that spouse is thinking there's a priority to provide more for that younger child that they've had with a different spouse because their adult children are kind of grown and taken care of. But boy, that conflict that might arise, and how would that make the older children feel if they're completely disinherited, and setting up kind of that new spouse for a lot of conflict. So
Yeah.
yeah.
And if you think a divorce proceeding can get ugly, just wait and see what happens when someone gets sick or passes away. I've seen it be 10 times worse than the worst divorce. I mean, it just really gets bad. So something to be mindful of. Pay attention to the bumps ahead. And that's really our job as lawyers, is to help you guys have a successful legacy. And it's to work through these issues.
Yeah, that's correct. So I thought what we would do is I'm going to give an example, and we're going to go through a case study of a client and what we had to do and considerations we put into balancing the different goals and issues coming forward. So I'd like you to meet our client Mark, and Mark has come in. He's married. His wife's name is Kim, and they have one child together, and they've come in because they have no plan yet. All right, so very common. We're going to talk about why it's so great that they've come in at this period of time. Now, while this is this is Kim's only child that she has. Mark has 2 children from a prior marriage that are now grown, and they have children of their own. So these are his 2 other children. Within their estate, when they're married now, they own a joint home together. They have rental property, they have brokerage accounts, they have life insurance policies, they have retirement plans. So you put that estate together, and we're looking at the size of their estate. It's and having no plan, this is where we get very worried about the no plans. What happens when you have no plan and you have that size of an estate? Because what we worry about is and inheriting money with no plan, okay? You know, I hate to put this out there and everyone knows it, but there's a 100% death rate, right? This is something that is a for sure thing that's going to happen to us all. And for almost every marriage, right, every married couple, there is a surviving spouse most of the time. They're not passing away together. That's a little bit more rare. So, and many of these surviving spouses, they remarry, you know, and some have registered domestic partners. And this is why we have to really think and have a plan going forward that's intentional. So it's time for them to plan. Good, they came in, because let's talk about what happens when you do not plan. And this is for everybody out there, but especially for blended families. What happens is the state has a plan for you, and that plan is called probate. All right. Everybody out there has heard of probate, and you know, there's a fear around it. And why? You know, first of all, why does their estate end up in a probate proceeding? And you know, it's a really low threshold in the state of California, Jim, to end up in probate. So most people in California, you know, if you own real property, that's going to be a qualifier. It could just be dirt. And, you know, it could be that the bank owns it all and you have a large mortgage. It doesn't matter. That's going to be enough to end up in a probate proceeding. In addition, there's a cap on a certain amount of money that you can have in your estate. So if you have, you know, over $166,000, then that is also going to be a red flag to end up into court to take care of the assets. They are well over that. They own real property. They have 2 pieces of real property. One happens to be in another state. Oh my goodness, what happens then, Jim? You've got 2 pieces of real property. They're in different states.
You got to go to the other state and start another probate case. It's a disaster.
Yeah. Now you've got 2 probates that your estate is going through with different laws. And
there's actually a technical term for that. It is called ancillary probate. So they would, when one spouse dies, you start a probate in, for example, California, and then you start another probate in Texas. And I can tell you the laws in Texas are different than the laws in California. And one big part of the analysis is looking at, just using an example, his property, her property, and their property. So you have to be really mindful of the characterization of property, whether it's the separate property. This is typically property that you bring to a marriage or you inherit, and don't transmute, don't turn into community property. So there's separate property, and then there's community property or marital property. And if you own real estate in another state, that state's laws, that the laws of the state that you own that piece of property, and in this case, Texas, they have a different set of laws. And those laws apply when it comes to dirt in Texas, real estate in Texas. So very important, if you're a blended family and have property in another state, which many of our clients do, very important thing to discuss with your lawyer.
Yeah. And probate, you know, why is it so bad, right? You look at the size of their estate. Well, one, it's very expensive. So, you know, and those fees for probate are set by statute. It's not like you shop around attorney to attorney and get to negotiate something down. I mean, those are automatic that come off the top. So, you know, if they have like, you know, a $2 million estate, Jim, how much do you think they'd end up paying through a probate proceeding?
Yeah, by the time it's done, probably $75,000 to $100,000 in probate fees, regardless of debt, by the way. So if you have a $2 million estate and owe $1.5 million, you're still going to pay that, you know, 100,000 or so in probate fees.
Yeah, so very, very expensive. You can see they, you know, if they would have just done some planning initially, they could have really avoided that and made sure that went the way they wanted to. Also in California, probates take on average about 16 months to go through. I'm saying that now, but you know, with COVID-19 occurring, our court system has been on a holiday, and they are so delayed in hearing cases, and they're not open yet. They just started opening for emergencies, but you can imagine how far behind they're going to be. And if I was to guess, I'm going to say probates are going to take a whole lot longer. Okay, 2 years or more. Not that we don't run across people in their 5th year of probate, and you can see that in a blended family situation, a good chance we're going to have a lot more fighting in the court system, and it's going to take a whole lot longer and a lot of money and time and burden and just heartache to have to go through this. So you do not want to put your family members through this, especially in light of what's been going on right now.
So how do you avoid probate? How do you keep it out of the probate court system?
Yeah, so the solution we're going to get to in just a second, but I thought I'd first talk about it's a trust. We're going to talk about that in a second and take you through how we're going to plan for them to avoid a probate. And that seems so simplistic. We're just going to create a trust, but there's going to be a lot more to it. So the when it goes through a probate, it really depends, like Jim was talking about, the characterization of your assets. And this is really important to understand. How did the property get acquired? Was it before or after marriage? But I think it's important for you to know California is a community property state. And that means that, a marriage or registration of domestic partnership makes those two people one legal community. Okay, so one legal community. So community property is going to be any property, real or personal, that or debt acquired during marriage. All of that is going to be considered community property. That's going to matter later down the road, how something's going to be designated. Separate property, a little bit different, is property acquired prior to marriage. So, of course, this happens all the time with blended families. They come into that marriage already owning property, or after the date of separation, or during marriage by inheritance or gift. Boy, do we see this every day. Someone's parent passes away during that marriage, and they've inherited a piece of property. And actually, with this sample case we're talking about today, this is one of the things that occurred. Mark has inherited a piece of property, and he might want to make sure that that inherited special property goes down to just his children, right? There's going to be a variance there. And how does he plan for that? What are the spousal rights to that kind of property versus, the children's rights? And it can be really messy because lots of people commingle their assets. So, they sell both their homes, they go in on their next home, and they kind of blend it all together, and it gets really complicated. Who owns what? Is it community? Is it separate? And, everyone out there knows that matters for a divorce proceeding, but it really matters at death. I mean, the characterization of your assets can lead it to go in a different direction than maybe you thought. So the laws out there are a little bit different as to what, a spouse is entitled to versus what the descendants of the person that died is entitled to. If it's community property acquired during marriage, and, both of the efforts have been put into that, then the surviving spouse is going to have a priority to that. All right, they're going to be able to entitled to that entire half of that community property when a spouse passes away. If they had, if it's a surviving spouse, and if they're survived by children, we have a little bit different of a characteristic. So it really does depend on whether the spouses each have children and how many children they have, because the probate code tells us, well, if they have just one child, this is how things are divided. If they have more than one child, this is how we're going to divide it. And it might not be going the way you want it to. In particular with Mark, he's inherited this separate property. He's got more than one child. So the probate code has an entire, rule as to what happens to that separate property. And it turns out that his spouse actually is entitled to a third of it. Right. And that's not what he wanted. But
of course, that's the $64,000 question. Is it community property or is it separate property? Because if the wife can prove it's community property, she gets the whole thing. So property, even though it's acquired by gift or inheritance, can be transmuted. So that's a fancy word for changing from separate property to community property. And I will tell you, it is a one-way street. It is very easy to transmute property from separate property to community, but it does not happen the same way. You can't just easily transmute community property to separate property. And to make matters worse, there is a presumption that all property acquired during marriage is community property. So if you want to prove that property is separate property for whatever reason, that person has what we call the burden of proof, meaning they have to show sufficient evidence that the property that was acquired was not, in fact, community property, but was really separate property. So The cure-all for all of this is deal with this while you're alive, because the parties can choose to identify property as community or separate with a writing. And typically that's done with an estate plan or a trust. If you don't do anything, if you kind of bury your head in the sand, you're just kicking the can down the road, and your family's going to be the one that really has to sort all this mess out.
Yeah, and you know what's interesting is a lot of clients might have had previous documents before they married another, their second time. And if they have an old trust that they haven't updated and it never mentions the new spouse, what happens then, Jim?
Well, the spouse can elect against their share. So they are treated. So what the law says, that's called I'm going to use a fancy word, pretermitted spouse. What that means is I do an estate plan in 2019. I get married in 2020. I don't update my estate plan. My new spouse can take her portion of the community property as well as her share of my separate property. So very important. The fact of marriage alters your estate plan. So it's very important. So that's one of those big life events. So if you've already done an estate plan, births, deaths, divorces, inheritances, those are kind of key indicators that you need to revisit your estate plan.
Hey, Jim, what if they've come to us and Mark says, well, I have a will. I put it all down there in that will. Isn't that going to avoid probate?
No, will is merely a list of instructions to a judge on how you would like things to happen. So in a will, you nominate an executor, you nominate a guardian, you direct how your property should be distributed, but ultimately the judge decides whether that's a valid document and decides who's entitled to inherit, regardless of the will. So a will can say something, but the property is actually distributed in another manner.
Yeah, so a will never be enough. So
Mhm.
remember that it's not going to do the job. It's not proper planning. So the solution that we talked about is a living trust. All right. So they will be what's called the grantors. They're the creators of the trust, and what they'll be doing is, retitling their assets, their bank accounts, their properties over into the name of the trust. During their lifetime, they are also the trustee. They're the manager of the trust. Nothing has really changed for them as far as control goes. It's still their social security number. They still have full access to all of their assets. And during their lifetime, they're also the beneficiary of the trust. It's for themselves. You'll always see those three positions when it comes to your trust documents. Now, this trust seems very simple while they're both still alive. We don't have conflict right now. But I'll tell you, one of the big things that occurs in all of our lives, 75% of our population will become incapacitated before they pass away. And so incapacity is where it is the first time that now we have one spouse maybe acting for the other spouse, and there's some children maybe involved that are not going to be so happy about the choices they're making. So this is going to be the first stage of conflict for, well, every family, let alone a blended family, when we have difference of opinion as to how things should be handled. So, keep that in mind. I wanted to mention right here, because we're talking about incapacity, I thought it'd be a good time, Jim, to talk a little bit about long-term care planning and how that works, because this is a huge concern for our clients, when it comes to long-term care planning. I mean,
Yes. Yeah. So here's a very common circumstance. By the way, guys, for those of you with a blended family, Tasha, I don't know what percentage of clients you
yeah,
meet with are blended. I would say it's probably more than 50%,
I
honestly.
agree. Yeah,
So I think this is, this is not an outlier, but this is
no.
kind of this happens daily in our practice
Hmm.
of blended families. But I want to pose this question to you. Let's say that Mark has a stroke. Now it looks like he's the older spouse. Mark has a stroke, and his nursing home cost runs $10,000 a month. That's the average, about just under $10,000 a month. Who pays for that? Does it come out of Mark's separate property, his separate funds? Does it come out of Mark and Pam's joint funds, or does it come out of Pam's separate funds? I can tell you, if Pam was my mother, I would say, Well, those Mark should be paying for his care. And if I were Mark's kids, I would say, well, maybe that should come out of their joint money, not necessarily from Mark's side of the money. So it is very important to have a plan. And I'm not talking about any elaborate, at a very baseline, some guidance that, look, if I get sick and I go, I need in-home care or nursing home care for $10,000 a month, where does the money come out of? What's the order of liquidation? Many of our clients buy long-term care insurance. So what many of our clients are doing now is they're taking $50,000, they're giving it to an insurance company, and in return, they immediately get $150,000 in coverage. So it's a 3X. And if you think about the probability of needing long-term care insurance, I just went through this with my mother-in-law. She passed away about a month and a half ago after a multi-year struggle with Alzheimer's. Very difficult on my wife. She was one of two primary caregivers. And I really wish they would have had long-term care insurance. But this is a great product because you can take this 50,000 and it becomes 150. And the old way of doing long-term care insurance is you would pay, and if you used it, you used it. And if you didn't use it, you losed it, right? You lost it. So it's use it or lose it. But the new way is you put this 50 in, you get 150. If you never take the 150 out, your family gets that $50,000 plus a little bit of interest every year. And that becomes part of your legacy. So many of our clients are looking at that. If that's something you're interested in, please reach out to us. And we had a question from Deb. What if I don't do anything with my 401k beneficiary? We'll talk about that.
We are going to get to your retirement plans because they're a very important asset that you need to plan around.
Yeah. So long-term care, very important, but at a minimum, if you've got an issue where finances could be a problem in your family. And by the way, all of this stuff comes out at the end. So if you think you can hide things, that doesn't really work in today's world. And so everything, as we say, everything sees the light of day. But it's something to be mindful of on how you're going to pay and at what bucket does the money come from.
Yeah, and we as planning attorneys, we're always thinking about long-term care because we're living longer and such a high percentage of people are needing it that we have to be talking about how are we going to pay for this? Where does it come from? What are the opportunities out there with, Medi-Cal, and what if I can qualify for that somehow? And can the family work together to make that happen? So there's just so many things to be thinking about, but that's something we can discuss in the consults. So they have this trust during their lifetime. And again, it's about balancing goals here. How do we complete these goals? One side, we've got the spouse we're thinking about for Mark, and we've got the kids. And remember that for him, right, he's got a younger child and he feels a little bit like he's raised those other two children and they're doing well. And he wants to make sure if something happened to him right now, his spouse will be supportive. And so with that younger child. But he also, he loves his older children and he wants to make sure there's kind of this, boy, it's really hard to balance out these goals. But what the risks are of not figuring this out is hostility, right? Between the children and the new spouse. It can absolutely just break up the family. And even if they get along right now.
Well, what we say is, the goal of estate planning is when you leave this world, because no matter what your religious beliefs, we all, like you said, we all die. And what happens next is, a spiritual question, but you will leave your family on earth. And for many people, the goal is if you guys were getting together at Thanksgiving while you're alive, after you're gone, I think it's pretty much everyone's hope that the family would continue to get together for Thanksgiving. But too many families go through too much. And some of these estate plans are so messed up where the clients don't pay attention to it enough. And it really gets so ugly that the family there's hatred. They never come together for another Thanksgiving.
Yeah, and I'll tell you, if you have children that you haven't spoken to in, 20 years and you're saying, out of sight, out of mind, they know I'm going to leave it all to my new spouse. They're not going to be involved at all. They won't care. They won't come back. That's just not true. And they have a set of rights and they're going to receive notice when you pass away. That's a legal requirement. So they're going to know they will be involved and they have a right to see the plan, believe it or not. And so you can't.
They have a right to inherit. Under California, there is a statutory right to inherit. What that means is you have a right if you're disinherited, or you don't like the way it's going, or you're inherited, but you're not happy with the plan, you have an absolute right to file a court action and just, put a match on the gasoline and really cause a lot of pain for a lot of people in your family.
Yeah, and I know that's scary to think about right now, but that's why you need a plan for it. I mean, you got to put something in place to, pour some water on that fire, and see what can happen. So we'll talk about some options with them with our planning. There's different ways you can balance these interests. One is outside the trust, and a lot of great tools you can use. One is life insurance. So a lot of times with blended families, if we want to leave most everything to the surviving spouse and still give them full control and access to those assets, but still want to provide something for maybe Mark's older children, why not get a life insurance policy and let it pay out to the older kids when he passes away? Give them a little bit of something, because in this situation, his older children are about the same age as his new wife. So it's not like, it's amazing to me how many clients come in and haven't thought of that yet, that their older children will probably never inherit. But it will all go to them when she dies. And then it's always like, well, you realize they're similar ages. And so that is something a lot of people haven't even thought of when they come in, is what happens. So why not give them, a little bit of something, get them off the spouse's back? There's got to be a way to provide for them. And Mark really wants to do that. He does want to give them something, but still provide for that spouse. So life insurance might be a great way to do that. And then also, Jim, specific assets, there could be something else in the estate that you can designate to go to them, maybe through like a pay on death designation, if that's the way you want to do it.
Yeah. So, right. So they're inside and outside assets. So they're
Mhm.
the assets that pass outside of the trust. And when we say specific assets, these might be IRAs or 401ks. And the last question was, hey, if I get married and I've got a 401k, does that affect anything? Something you need to pay attention to is ERISA plans versus non-ERISA plans. Now, ERISA is the 1974 federal statute. It's a federal law that birthed or gave us 401ks and IRAs and all these tax advantaged accounts. If you have a 401k, your spouse is your statutory beneficiary unless the spouse just says, I don't want it, right? Unless they waive their claim. So by federal law, the spouse is the one who inherits a 401k, whether or not the spouse is named as the beneficiary. So one of the things that you can use is you can, for example, we have some clients who say, well, I want to set everything aside for my wife, and then when my wife dies, it goes to my kids. One of the downsides, and that's passing through a trust, one of the high-level downsides of that is your surviving spouse. So when you're gone, that's the person, that's what we call a surviving spouse. The surviving spouse and your children are going to be linked and intertwined for the surviving spouse's lifetime. Sometimes that's okay, and sometimes it's not. It depends on your individual situation. So I know when we meet with people, Tasha and I will meet with clients. They'll say, well, I want to leave this asset to my wife when I die, and then my children. We do in the counseling process go through alternative structures. Well, what if we gave your wife, or what if we gave your kids the IRA and your wife the house? Or what if we gave your wife half the IRA and your kids half the IRA? Now, an IRA is not a 401k, so you don't have that statutory requirement to leave it to your spouse. But this is kind of part of the counseling process that we like to walk through our clients
Yeah.
with.
So like a specific asset could be the IRA, could be we do, and we will with Mark, we're going to go through next, what we did with him with his IRA to really plan out some to the spouse and maybe some to the kids. Inside the trust, like Jim was saying, that is something that is very unique to each client, whether we change the structure of the trust for a bit more control at first death. Are we going to set aside some assets to reserve them and make sure they get to your heirs, right? A little bit more control in that structure. Or is there going to be, like a specific gift off the top, maybe to your children, as a way we can deal with that? Give them a little something when you've passed away, some cash maybe. And we're going to do that for Mark in particular. He's got that property he inherited that's sitting out of state, and it generates a lot of income for them. And when we talked about it, he said, well, I want to make sure that that income gets to my spouse throughout her lifetime. Like, this is really going to set her up. But ultimately, when she passes away, I want to make sure that property passes down to my line of heirs. So give her the, the income profit, and then make sure it goes a certain way. And there's absolutely a way we can structure that within the trust, so we can accomplish their goals. Outside of a trust, we kind of have a disaster, but we can do a lot of planning within the structure of a trust to make sure we're accomplishing your goals. All right, so we're going to talk now about your retirement plans, those IRAs that we call them. And when we're talking about IRAs, we're talking about qualified plans. So what we're not talking about is a pension. That's a little bit different, right? And so this is a huge asset for most of our clients. Probably their largest asset, and most of the time might be even bigger than their real estate that they have. And when they pass away, it tends to all still be there, right? And starting at, well, now age 72, we start taking out those required minimum distributions. And by the time that they pass away, it might have been growing a little bit more than they're taking it, or at least the same rate. And we know that over their lifespan, it tends to all still be there when they pass away. So a lot of planning, we are always talking to our clients about their retirement plans. What are their goals? What are their worries? What are their concerns about who's inheriting it? Because we want to plan around that, in particular with blended families. Okay, so we'll talk about that. I wanted you to learn a little bit more about the rules of your retirement plans, though, and how they have changed due to the Secure Act. So the Secure Act out there, Jim, give us a little bit of history behind this, because this is one of the biggest changes we've seen in retirement legislation in decades.
Yeah, so there was a really great planning tool that pretty much has been eliminated for most of our clients. And so what this means is when we work, at our law firm, we have a 401k, and our law firm does matching on the 401k. So I'm a super big proponent of employees saving for retirement. And so and Tasha, you have a 401k. So when you make that contribution, it's deducted from your pay. So you don't pay tax on that money, right? So when you put your money into your 401k and then our firm matches, all that money is pre-tax money, meaning taxes haven't been paid on it yet. And then when you reach 72 and a half and you retire and roll your IRA over, when you hit 72, you have to start taking money out, and you pay tax on that money. So it wasn't paid when you put it in, years ago. And then when you start taking it out, you have to pay tax on that money. And it's about 3.5% at age 72, or 4% or something like that. So when a person dies, they can leave their IRA to their spouse, and that's called a spousal rollover. So the spouse just kind of steps into the shoes of the spouse. So Tasha, you pass away, you leave it to your husband, and he steps into your shoes and continues the minimum distribution schedule over your lifetime. By the way, your minimum distribution schedule at age 115, you only take out half of your IRA. So you will never, if you only take minimum distributions, mathematically, you can never deplete an IRA. So when a child inherits the IRA, it used to be that the child would take the money out over their lifetime, meaning if you're 50, you take it out over a 30-year life expectancy, you're taking 3% out a year. Well, if the account grows by 7% and you take out 3, that means 4 is left over. And then that snowballs year over year over year over year. And so this was a fantastic planning tool in the past. Well, the federal government said, no, we're pushing all that to the side. In very limited circumstances do you get that lifetime stretch, and what we call that is a stretch IRA. The new rule is you either take the money out in 1 year and it is all taxable. So if you have $1 million in an IRA and you leave it to a kid and they take $1 million out and they add $1 million to their income in California, folks, I can tell you the tax bill is about $500,000 in the state of California. It's about half. So it's a big amount of tax to pay. And by the way, 87% of the time, that's exactly what happens. 87% of IRA accounts, when somebody dies, all the money comes out and is paid to the beneficiary. Now that's large and small accounts, right? So what's the new rule? The new rule is what I call a 10th year rule, or a 10-year rule. So if somebody passes away with $1 million IRA in 2020, the beneficiary takes that money out, doesn't have to take any money out for 10 years, zero. And in that 10th year, has to take all of the money out. So that million over 10 years, the rule of 72, for those of you who have heard of that, the rule of 72 means that money that earns 7.2% rate of return doubles in 10 years. Money that earns a 10% rate of return doubles in 7.2 years. So if it's a 7.2% rate of return in 10 years, that $1 million IRA becomes 2 million. And then the beneficiary takes the money out. Well, now they're paying $1 million in tax, but they have $1 million left over after paying the tax. That's if everything goes right. But there are a lot of ways it can go wrong. You have to check a lot of boxes. You have to do a lot of things before a certain period of time after somebody passes away. And if you don't follow those rules, either the money comes out in 1 year or it comes out over 5 years. The whole point of me going into this, and I hope I haven't lost you, very complicated set of rules. We are experts in this field. So the Secure Act has really changed the landscape for a lot of our clients. And many of our clients are leaving their IRAs in an IRA legacy trust located in Nevada with a Nevada trustee. We've helped many clients with that. The reason is you, at least under current law, delay paying California's 13.3% income tax when the money comes out. Okay. You can only do this after you pass away. But that, at least under current law, delays it. Hopefully under future law, we can avoid the 13% tax entirely. So on a $2 million IRA, saving your family about $250,000, it's a lot of money.
Yeah, so huge changes as of January 1st this year that might have been drawn a lot of attention and then kind of dismissed once COVID came about because our attention was, elsewhere. But it just was huge. Prior to January 1st, we just, like Jim said, we had so many planning opportunities with what's called this stretch out, leaving it to that next generation and really letting it grow for them as a retirement plan. And that was kind of stripped away. And so there are exceptions to that rule. And I want to mention them because for Mark, we're going to use one of these exceptions, to get that stretch out, to give it back. And one of those is minors. So I'm married, I have 3 minor children. If I was to pass away, and so did my spouse, my children are young. That's just public policy. We don't want them to come into a lot of money. So it's that 10-year period is going to delay until they're 18. Well, that's not great either, right? I don't really want my kids to have access to our retirement plans at 18, but it would delay. If they go to college, it delays again until, an extra 10 years after that point. So up to age 26. But it could be you really don't want your minor children to inherit, want more control. I don't really want them to have the option to pull it all out. So again, control ends up being something we really have to talk about. But at least there's some public policy there that a minor child isn't going to draw it by the time they're 18.
It's also important. It's also important to point out, if you do have a minor child or a disabled child or chronically ill, and chronically ill under the Internal Revenue Code basically means you can't work, for whatever reason. You're not disabled by Social Security standards, but you're chronically ill. Those people have a different distribution schedule, especially for a minor, somebody under 18. If you don't do proper planning, if a parent passes away and leaves an IRA to somebody under the age of 18, you must start a guardianship in California if the child's a resident of California. That's probably about $15,000 to get started, and it is total pain in the neck. You're under the wise and watchful eye of the court, but I'm not sure people want a court looking over their shoulder for every move that they make. And then once the kid turns 18, they can yank all the money out and go buy a car or buy their boyfriend a car. So it's either like the boy buys a car or the girl buys a car for the boyfriend. So that's what we've seen in the past.
Yeah, so you can see the planning goals are really different for everybody because there could be situations where you have a loved one, on government benefits, and that's a huge problem with inheriting anything, let alone an IRA. In this circumstance, our client Mark, he has a really large retirement plan, and there's a lot of other income coming into the marital estate to help support that spouse if he was to pass away. And so what we talked about for him is putting a little bit more control on that retirement plan when he dies and putting a little bit more planning into it. And Jim had mentioned that IRA trust. That's how we accomplish this. It is a separate trust, completely separate from that marital trust that they have together. And it only handles those retirement plans. Nothing changes while Mark is alive. He can fully control and take distributions. It's still his. The only thing that changes is the beneficiary designation form. That's how you leave your retirement plans, right? It's not in your trust. Do not designate your trust. There's a problem with that. But his beneficiary designation form is going to say, I leave this to my IRA trust. And when he dies, it's going to drop into that IRA trust and go according to its terms. Now, he has a little bit of two goals he's trying to achieve. One, he has a grandchild from his oldest daughter that is a child with special needs. That's an exception. This is a huge switch for our planning for our children with special needs, because what a great opportunity. They're an exception to the rule. So now, instead of it paying out, and losing all that in income tax, we can take advantage of that and leave it for this child and let it grow there and let it stretch out for this child's lifetime and protect it from kicking her off of government benefits. So if she's receiving Medi-Cal or SSI, this is a way that we can provide for other things, right? Things that the government's not providing for. So a huge benefit to this child with special needs that he's really worried about. He really wants to make sure that she's set up very well if he was to pass away, so it can provide for anything else that the government's not providing for. So a portion of this IRA trust is going to be distributed out and controlled by somebody else, possibly in Nevada, Jim, for those, those better tax benefits for this grandchild with special needs. However, there is another percentage of it, a larger percentage of it, that he's going to leave to his spouse within the IRA trust. So he can control where it's going to go when she dies. So she can't just go into her beneficiary designation form and change the direction. And it's not necessarily about trust. I mean, sometimes it is, but it's just a guarantee. It means it goes to the spouse. He's leaving her 80%. 20% went to the grandchild with special needs. 80% falls to the spouse, controlled completely through this IRA trust, still gets distributions for what she needs during her lifetime. It's going to kick out to her. And then, though, when she passes away, it's going to distribute equally to those 3 children that he has, 2 from the prior marriage and the one he has with his current wife. And of course, it's completely structured so we know what happens if any of those people have passed away. So he's obtaining, we have now reached his goals of making sure his spouse is being provided for and has enough to be cared for if he was to pass away, but ultimately controlling where it goes when she passes away, and she can never change that.
Yeah, and otherwise, if he were just to give the IRA to his wife when he passed away, she can leave it to whomever she wants, and she doesn't have to leave it, even if he says, I'm leaving you this IRA, but when, if whatever you don't use during your lifetime, it has to go to these other people. The only way you can do that is with a trust. That's it.
Yeah, and boy, these IRA trusts are just such a good planning tool for our blended families. I mean, it applies to a lot of families, but in particular, what a great device for all of you out there that have this.
We have another question. When a spouse inherits whose life is used for the RMDs, the decedents, the deceased spouse or the survivor, in a spousal rollover, that just rolls over to the surviving spouse. So the survivor is under the same rules. And especially in this situation with Mark being older, if he dies and his wife is under age 59 and a half, if she merely rolls the IRA over, please pay attention to this. If she just rolls the IRA over and she's under 59 and a half and she says, well, I'm just going to take money and live off this IRA, she's subject to a 10% penalty for an early withdrawal. So if he's 70 and she's 40, that's 19 years of her taking distributions out of the IRA. They may want to look at an alternative strategy. That's something that Tasha and I can help with, but in a way to avoid that 10% penalty. So that's very important to consider. So this is just not willy-nilly. This is not a do-it-yourself project. It's walking through a minefield, right?
Yeah, absolutely. All right, so that's a big one. We're going to move on to another way that many estate plans fail, and it's a huge decision for every blended family. It's choosing your trustee. So remember, that trustee is going to be the manager of the trust for them, and first they arise during incapacity. It's always incapacity. Who's going to be that person to step forward and make those calls fiscally for how we're spending money and for what and who has that control. Is it going to be the spouse? Is Mark going to have the spouse, continue to be the trustee? Usually, usually married couples want their own spouse to continue to care. If they're both incapacitated, or if one has passed away and one is left, well, they might want different people, right? I don't think that his wife wants his older children to do it unless they have a really great relationship. Now, when it comes to choice of trustee, it could be a family member or a friend, right? We know that you want to make sure they're fiscally responsible and that you really trust them, because the great thing about the trust is that there's no oversight. The court is not involved whatsoever with this trust. So, can they just take money and put it in their pocket?
I mean, it is a crime. It's embezzlement. Yeah, they can. It's embezzlement.
Yeah.
Punishable. It's a felony, but they
Yep.
can.
Yeah, and who's watching them? If you're incapacitated, who knows? We have a lot of elder abuse out there where their own family members, this is so common, their own family members are the worst case of this, that are, taking money from the trust. So really careful on your choice of trustee. And you could have family members that are a perfect fit, and that's okay. I don't want to dissuade that, but you can see for them as a blended family, his choice is going to be really different than his wife's, so it could be we need to have an alternative. And many of my clients don't have family members or friends to name, or they just don't want the conflict. They don't want to name one of their children because it causes, so much controversy. So there is something like a trust company, like the one in Nevada, or a bank, but there is something in between called a professional fiduciary. These fiduciaries are licensed in the state of California. They have a lot of oversight. They go through background checks every year. You can meet with them, right? You can interview them, get to know them, find an independent party that can maybe step in and cool some of these negative feelings within the family when it comes to control. So I think the important thing to know is you have options, and we can talk about those. And if we're worried about children from another marriage coming in and causing conflict, there's, you have opportunities to make a choice. But this is how things fail constantly, is the choice of trustee.
We have a question from Ann. Are you saying that having the IRA trust as the beneficiary of an IRA, the Secure Act does not apply? The surviving spouse need not spend it down within 10 years. I'm not clear on what you presented. Well, let me tell you that the Secure Act is federal legislation. It always applies, but the Secure Act maintained an exception for spouses. That being said, we are still waiting further, because it's passed in December. By the way, December 2019, totally different world, right? We're living in a completely different world. We are still waiting for some additional guidance from the federal government, from the Treasury Department, to clear this up, which is normal when you have big legislation. It's typically followed up by rules. But planning for spouses is very, very complex. There are very few lawyers. I can tell you, Tasha understands this, and I understand it. Very, very few lawyers, very few CPAs, very few financial advisors understand anything beyond a real surface level knowledge on this. It may depend on the age of the spouse, whether the spouse is 10 years younger or not, or more than 10 years younger or not. It may depend on whether the spouse has already, the deceased spouse has already started taking minimum distributions or hasn't. So there are a lot of factors, and that's something where we just sit down one-on-one with you, talk about what are your goals, and then we fit the pieces together to reach your goals.
Yeah.
And then Susan writes, what happens if the named trustee does not fulfill responsibilities and ends up doing nothing? Well, the 13th Amendment to the United States Constitution, among other things, prohibits involuntary servitude. What that means is you can never, ever force somebody to be trustee. If they never agree to serve as trustee, then, there's no requirement. That's a federal protection. No one can make you do that. However, once you start taking on the duties of trustee, once you sort of pick that mantle up, you have 100% unlimited personal liability for everything that you do or don't do as trustee. And secondly, if somebody's not doing their job, the typical way it goes is if they're not doing their job, you say, knock, knock, knock. Hey, can you please do your job? And, if they say no, or I'm not interested in it, okay, do you want to resign? And then we go to the next trustee in the document. So it's important to think about, how many layers of trustees should you have? Because that first one, they may say no, or they may not be doing a good job, or they may say, I'm done. So then you go to the next one in line. The last resort is to go to court, but there is an alternative to going to court and have a judge remove them that Tasha will talk about in a couple of slides.
Yeah, those are good questions. Thanks for checking the chat, Jim. I missed that. Okay, so now that we've talked about the trustee, and in their situation, Mark, as his successor trustees, has his adult children on there and very responsible, and he's okay with them stepping forward. But his spouse, she's actually named her brother and a couple other family members, so they have different lineups, and that's okay. Same with healthcare choices that we're going to plan for them. They're going to have different lineups. That's okay. They have different family members. You can see there's always going to be a little bit of a mix-up with a blended family. So what about their children and how they inherit? This is really important to start thinking about, because inheriting money, it's risky, all right? This is a little funny because he's so young, but yes, it sometimes depends on age when people inherit money. So I'm talking about at the end of it all, when they both passed away and the assets are being, given to the children that are left in whatever percentages and however we planned it out, why are we so worried about the beneficiaries that are now accepting the inheritance? It's because we know 50% of people, they blow it right away. They go right through their inheritance. All right. And some of that might have to do with responsibility and what age they are. So we want to make sure we talk about that, what age is very appropriate for them to step in and control that money. And it's, usually not 18. I'll put a little flag out there. Very rarely. I'd say on average, people are choosing around the age of 25 to 30, somewhere in there. But I have plenty of clients that come in and say 65. You put 65 on there, right? And that's okay. That can sometimes be what works out really well for them. But what we're worried about might not be them at all. It could be third parties that are out there. His son owns his own business. And, anytime we have business owners out there, we worry about litigation. We worry about liability. And his business has been sued a couple times. So we want to structure something where we might have a possibility to protect the inheritance from those kind of things, the third parties, divorce, their own divorce, the children, right? Divorce from creditors, from what we call predators, which could be people in their life that have really bad suggestions of what to do with that money if, we feel like our loved ones can't make good choices. And how we protect them from that is we plan for each one of them individually. And it depends on each one of our loved ones. They're very different. But what we plan for is something called a continuing trust. They're going to inherit their share instead of outright and just coming into their estate and just being subject to all of the liability and a future divorce, right? Which is really common, as everybody knows, still 50% divorce rate out there. It's a way to keep it separate. They're going to inherit into a trust, but they're different depending on our loved ones. So one kind of trust would be called an inheritance protection trust. This is the type of trust where, his son, who owns his own business, he's very responsible. We want him to have control and access and to manage it. So he's going to inherit into this type of trust that he gets to control. He gets to be his own trustee, right? So if he wants to and he hates it, he can take it all out and give it to his spouse. But while it's in this trust, he has an opportunity at any point in his life to foresee something bad, right? It could be a litigation, it could be divorce. He can step out of his role as trustee, put his best friend Billy in there for a while, and he locks the box, right? Nobody can get to those assets. He can't get that kind of protection any other way. It's such a great flexibility to give them, and you're still giving them control. Let him make a choice, but now you've set it up in a way where he can have protection if he wants it. Now, for those loved ones where they really are not in a place where they should be controlling the assets themselves, we construct a continuing trust, again, already created within our trust, something called a DOLE-IT-OUT trust. It's not a legal term. It makes just a lot of sense. We're going to dole it out a little bit at a time, all right? But the beneficiary, in this case, it's his daughter, is never going to control these assets as trustee. And in this situation, it's because she hasn't been able to work in a really long time, and we're worried about her being on public benefits in the future. She's got a lot of debt out there. So, creditors, we're worried about a lot of different things with how she manages money. So we thought this would be a great way for her to inherit. We're going to put somebody else in charge of this trust for her in the meantime. So we've protected the assets. And in this situation, we ended up putting, her brother doesn't work for everybody. It could be somebody else. I'm just saying for her, it ended up being her brother. And he's going to provide, if she is on public benefits, fine. You know, he's going to make sure to hold it back and just give for things that won't kick her off public benefits. If she's not on public benefits, then he can distribute whatever her needs are. It could be a monthly stream, like, hey, sister, how about $4,000 a month? Does that sound good? But what it does is it's already locked the box. We already have it completely protected from divorce and creditors and bankruptcy and maintaining those public benefits. But it gives her a really good quality of life. It's going to make sure it's going to last for her lifetime. So these are the type, again, they can be structured very differently, but this is just a sample of what we did for him, for Mark and his wife, as to how they're going to inherit. And keeping in mind that their other son, their joint son, you know, we had to prepare guardianship documents and make sure we had the right person to step forward to be trustee for him until actually age 27. So we set up him a continuing trust as well, so it can be protected, his assets. And the important thing to remember about these continuing trusts is that, you know, they're irrevocable. You can't make changes after the grantor has passed away. So after Mark and his wife pass away, there's, you know, what if we need to make a change? We need a new trustee. Everybody, like Jim was saying, said, I don't want to do it. You know, the brother says, no, thanks. I don't want to do this anymore. And like Jim mentioned, it used to be you could go to court to fix that. Like the laws have changed. You know, we need this new power in the documents, or this is vague, I don't know what this means, or I want to step down as trustee. And that is expensive, like it always is, to go to court. We don't want to get the court involved. And so the more modern way of estate planning and what we do in all of our documents is we include something called a trust protector. Trust protector is like a superhero feature. Essentially, the law firm, we typically sit in all of our documents as the protector of the trust. We are not the trustee. Don't be confused. We are not watching your trustee, and we will never act as a trustee. But what it's doing is it's allowing that trustee to have someone to go to and make a change. They're going to come to us, and the brother's going to say, I resign. I don't want to do this anymore. We need somebody else to step forward and be trustee. We don't have to go to court. We can just sign a piece of paper as a trust protector and go ahead and put in that new trustee. We fix the problem, right? So this is just a really great modern way to make sure that these trusts are going to last for their lifetime, because they're meant to do that. They're meant to be for asset protection.
Yeah, let me give you a hold on. Can you hear me? Let me give you a quick example. We met with some clients. The son had a ranch with the parents in California. They were 50-50 owners. Son owned 50, parents owned 50. They did their estate plan. We put a paragraph in the trust that says the parents' half of this particular ranch goes to the son. Pretty basic. There were other siblings involved. Well, the parents and the son sold that ranch in California and bought another ranch in Texas. Same deal, 50-50. Son owned 50%, parents owned 50%. The parents never came back in to change their estate plan, and the parents died. And so the legal effect of that ranch having been sold, where the trust said, give our half of the California ranch to this one son. Once that California ranch was sold, then that half just became part of the larger estate. And that one son who was supposed to get half the ranch would not have gotten it. So one thing we were able to do as trust protector, and this is super important because it saved the family probably, frankly, about $30,000 in legal fees, is we were able, with the single stroke of a pen, to change the terms of the trust. And everyone agreed in the family. Everyone knew that the one son was supposed to get half of this ranch, but the trustee couldn't distribute the Texas ranch because the trustee has to follow the terms of the trust. They can't deviate. So the trust protector was able, and I was actually the trust protector, I was able to change the trust to leave the Texas, the half of the Texas ranch, to the one son. And the family was so happy because we would have had to have started an action in California and then another one in Texas. And that's why, you know, typically it's, if you're going to court, it's about minimum by the time you're done with fees and filing fees and attorney's fees, it's about $10,000. When you add another state in, it tends to add another kind of double. So that's where I get the 30. But the trust protector, fantastic tool to resolve problems. And a trust protector, you know, here's a way to think about it. A trustee has power over trust property, and the trustee must follow the terms of the trust. A trust protector has powers over the trust and powers over the trustee, but is not a trustee. So these are powers so that if the underlying factual situation changes, the trust protector can change the documents without having to go to court.
Yeah, and it might not be often that we have to use this and implement it, but I'm telling you that when we do, it is just so significant. You'll be so glad that you have it because it's saving so much time and money and saving the estate from having to go through court proceedings. And you got to just think of it as that like break glass. It's an emergency. And that's what the trust protector sits there for.
All right, so Candace asks a question.
Mhm.
Should we put one of our adult children on our
Oh.
account as a signer? All right, a signer is one thing. So there's
Mhm.
two ways, but here's the problem. When you go to a bank, you're dealing with typically a lower level person. Whether you're a signer or a joint owner, those are two different things. A signer has signature authority but does not own the underlying account. If you add someone to the account, and the way you know is you'll typically see their name on the statement, under California law, whoever the last man or woman standing is gets the account. Now, there's been a recent change in California law through a case, but the bottom line is if you put your kid on an account, the likely result is they will end up with the money and they don't have to share that with the siblings. So that can be really dicey. And frankly, it can really tick off a lot of family members because, you know, we've seen, Tasha, we've seen this. Somebody dies, a kid gets $100,000 account and says, well, I talked to my lawyer and I don't have to share this with my two brothers and sisters, right? With my brother and sister. Those brother and sister aren't going to be happy with that, right?
Yeah, and I think there is a lot of confusion too, is how those accounts are titled. And I'll just tell you, best policy is everything should be titled in the name of the trust. And if it's entitled in the name of the trust, you can't add a co-signer, right? You'd have to add a co-trustee. They're very different things. So there is some confusion there. Well, I just want to be added on, and they'll say, go see your attorney because it's not an account you can add a co-signer to. You have to add that trustee onto the trust. And that's sometimes our clients, it's time period to do that. You know, whether they age or they've lost a spouse, they want to have a co-trustee with them helping them pay bills. Well, great. We can do that under the trust, and it's going to be a lot more secure, a lot more control during incapacity, and we'll appoint that person as a co-trustee with you and get them on that account. But joint ownership is so dangerous. It's dangerous with real property. It's dangerous with those bank accounts. It can go in so many wrong ways.
Yeah, and especially too, if you add a child, and we see this a lot with real estate, where somebody adds a child, they'll put it in joint tenants or something, you know, mom and dad will transfer it to mom and dad and the two kids, all four of them as joint tenants. What happens when one of those kids gets a
Yeah.
Think about that, or declares bankruptcy? You know, folks, there are a lot better ways to plan your estate than just adding people to title. But before you do that, really check in with someone, a lawyer who knows what they're talking about.
It's not worth it. It's never worth it to try other alternative methods to try to avoid probate, especially with blended families. Oh my goodness, it just goes the wrong direction so many times. So it's not going to be worth it. You got to get a plan that's going to work. Really important. And with that, I'm going to go forward and remind you that, you know, everything sees the light of day, right? All will be revealed. I'll tell you what you can't do. You can't have no plan, right? You can't just not plan at all, let it sit there and hope it's all going to work out in the end. I really encourage you, put your family first, have that conversation, however difficult it's going to be, with an attorney, and make a plan to accomplish your goals and make sure that this is going to be successful, because it's not something you can brush aside and think it's going to work out in the end.
Yeah, you know, we handle sometimes we handle matters that go to court where people start fighting, and this is so true. Everything sees the light of day. For those of you who have ever been involved in a lawsuit, you know there are depositions. You raise your right hand, and an attorney's asking you questions. You got to produce all the documents and emails and text messages. That stuff's all captured. You guys know that. All of that stuff is captured someplace. And then, of course, all the documents, but you have to produce all of that stuff during a litigation setting. And if you don't produce it, then you're frankly kind of penalized, and the judge is going to penalize you in the case. And then Deb had a question here. Can I just give all my property to my kids during my lifetime? Well, there's an artful way to do that and an inartful way. As a general rule, I would pump the brakes on giving all your property to your kids during your lifetime. Now, it's one thing to give you know, grandma's silverware or grandma's dishes or a car or stuff. Okay. Set that, all that stuff aside because there's a good reason why you might want to do that. But should you give your house to your kids? Well, if you buy something for $1 and sell it for $3, you pay tax. You pay capital gains tax on your $2 gain. If you give that thing that's worth $3 to your kids, they get it with what we call a cost basis of $1. Now, all that means is if the kid, so I buy something for $1, it goes to $3, I give it to my son, and then he sells it for $3, he's got to pay tax on the gain of $2. If I hold that until I die and my son inherits it, the thing worth $3, he can sell that thing for $3 and pay no tax. So there's a real tax reason not to give your property during your lifetime, but forget the tax reason. The problem if you give your property is you've given your property and you don't know what people are going to do. People, guess what, folks? They die out of order. What does that mean? Did your kids die before you, or some of you may have lost a child. It just happens, right? How are you going to get that property back? Who's going to get that property? What if they get divorced? What if they go into bankruptcy? All these questions. So as a general rule, check with a qualified lawyer who, you know, who's an expert in this field, like Tasha and I are, before you start making gifts to people or doing an estate plan.
Yeah, and I'll just add there, because we are thinking so much about long-term care. You gift all your assets away, you're going to be kicked off of Medi-Cal, not be able to you receive those public benefits because you did not work with an attorney to do it right.
Right. And
And
you're
so,
either going to be ineligible for 30 months or 60 months.
yeah.
So 30 if you give it away yourself, 60 months if you give it out of a trust. Now there's a way around that, of course.
Mm-hmm.
And then you can come talk to us but that's,
Mm-hmm.
you know, a topic for another day.
Yeah, exactly right.
What you need to know before you hire the right lawyer is available on Amazon, and it is a bestseller on Amazon, and that's me on the back. But this is a great, it covers essentially the top 10 estate planning mistakes that people make and takes a deep dive into a lot of these different, a lot of the things that we've talked about, and a little bit deeper dive into some of the subjects. So we've had a lot of questions. It looks like we have one more. Oh, thank you. Oh, well, that's very nice.
Wonderful.
Going once, going twice. Looks like we're done. All right, guys.
All right.
Have a great day.
Thank you so much. Please just be intentional with your planning and don't procrastinate. You got to get this done. We see it every day, and the court systems are just slowing down. So be intentional with your planning and give us a call, and we'll help you out and get you a plan that will be successful. All right. Thank you so much for joining us.